Hey, Brian Parker here again, your old buddy, attorney Brian Parker. This is an oldie but goodie. It's actually, I'm the oldie and this is a goodie. This is about a student loan debt buying lawsuit. Now, you've seen me analyze the debt buying lawsuits in the past. It's all the same approach. The difference in this one, it's a new company. It's called CASA Receivables Management LLC. And this particular analysis will be the same as most, as I said, with the debt buying cases. However, this has a unique twist. In this case, usually what I'm saying to you, here's the creditor, here's the broken chain of title. Now this company has come along and said, we own the debt. In this case, uniquely part of perhaps a lot of student loan cases is the fact that they did not have the original creditor before any of this started. And you're going to see what I mean by that. So we're going to put up 4 questions I'm going to ask today, and the answers will show you how to analyze a student loan lawsuit. This one in particular, student loan debt buyer lawsuits generally. So the 4 questions. When is a predecessor in interest not a predecessor in interest? When is a creditor not a creditor? Why does a debt buyer or student loan purchaser not state specifically why it owns a debt? And of course, your favorite, what to do with the debt buyer or student loan documents from the lawsuit. If you've watched my videos in the past, what do we do with the documents? Their own documents, what do we do with them? What do we do with them? Right again, we use their documents against them. So that question's answered. So the definition, Cindy put that up, the definition of a predecessor in interest from the Webster's Dictionary. Yes, I know this sounds boring. I'll get to this real quick. The predecessor in interest is the following: a person who previously held the rights or interests currently held by another, or a party with whom another is in privity. When you hear the word privity in legal circles, they are talking about contract. Really, are you in privity with this person? Are you in privity with the person you did contract with? A good question in contract analysis, are you in privity with third-party beneficiaries or third parties that purchased a loan? So you would be in privity with whoever owns the lawsuit that you're being sued upon. So that's one analysis. And most of my analysis is, I don't know who this company is. They don't own my debt. So that's a privity question. A little legal info for you there. So let's look at the first page of the lawsuit, Shazamsky. And you can see right there, CASA Receivables Management LLC. And I want to focus on the very genesis of everything I'm telling you to do vis-a-vis who the heck is the creditor, as opposed to usually when I go, here's the creditor, there's not a perfect chain of title to the guy that's now suing you. So Cindy, emphasize paragraph 3, Shazam. So I want you to look at that. Let's read it together. Sally Mae Bank was the original creditor. Okay, leave it alone right there. Now let's go see if there's wait a minute. For some reason, and you're going to see how weird this is, or successor in interest to the original creditor of the debt at issue. Well, they're using the word debt, so hats off. In the matter and opted to relinquish ownership of same. So I'm not sure who opted to relinquish ownership, and we don't know here if it's the original creditor or successor in interest. But let's keep reading. CASA Receivables Management by virtue of legal or equitable assignment. So this is a case of saying too much. It probably wasn't drafted by an attorney. If you have a point, state it and move on. And again, while this probably doesn't apply, you need a sentence to tell the truth. If you have several sentences to explain one point, you got to start questioning why. And in this case, on top of everything else, they're saying they've received it, CASA is, by legal or equitable assignment. Well, which one is it? A legal assignment we've discussed many times. An equitable assignment has similar traits of a legal assignment. However, it's about a future claim or a future assignment that a court in a court of equity says, yep, there was an assignment. So they can't really say it's an equitable assignment previously from the creditor when an equitable assignment is about a future assignment to be determined by a court. So that third paragraph is a whole plate of wrong. What's a legal or equitable assignment? Who is the creditor? You're going to see, if they're just left well enough alone, they'd have a better case. So what I do is I create my counter affidavit. I'll put that on the video attached in Word for you to use in this and other debt buyer cases, of course. So number 3 of my answer, which will be on my video in Word, says, denied as plaintiff does not own the debt as shown by the lawsuit at paragraph 3 that tries to create an original creditor without actually stating or proving anything. That actually is from my counter affidavit, and that's what you do. You don't admit or deny, or you be in detail why they're a whole plate of wrong. One of these days I'm going to use is a whole plate of wrong in my affidavit. I think I'll do the next one. So I go further and say, further, did CASA obtain the bank by legal or equitable interest? And from whom? Sallie Mae Bank or the successor in interest? Who? Question mark. I'm saying that to you because we say that in our counter affidavit. And as you know, the counter affidavit, once you've done the counter affidavit, all the work for the whole case is done generally for you. That same stuff jumps, or as we said in my last video, plunking alert, it plunks right down into your answer. So the very stuff that you've created now is your answer. And then on number 4, I say denied with no reference to who the predecessor in interest is, and nothing shows it is a Sallie Mae Bank, the original creditor, or successor in interest, the original creditor. Who is the original creditor? So the chain of title can begin. That seed of doubt is going to flourish into a giant beanstalk by the time I'm done with this, and you too. So if you will look, let's put up number 4 of the complaint, Cindy, Shazam, just number 4. Plaintiff's predecessor in interest extended an offer to enter into a contract with defendant. Keep thinking, what is going on here? Why don't they just say Sallie Mae Bank? Because isn't that what happened? Sallie Mae Bank and you had privity, and Sallie Mae extended an offer which you accepted, and then they paid you. But debt buyers, out of the mouth of victory comes failure. They just keep talking and screwing it up and then their BS support of a lawsuit that is just vague ambiguities will be used against them. Keep in mind, this is a machine that's pumping out thousands of these and doesn't have time to be specific. So it creates a one-size-fits-all. So 90% of these cases they know are going to default. We, as I always say, live in that 10% where we actually take their pleadings and their documents and use them against them. So the lawsuit of CASA and the answer and the counter affidavit I've written in Word is attached to this video for you. So some of the things I'm going to say in my counter affidavit. Was Sallie Mae Bank the original creditor? Why is paragraph 3 so vague and ambiguous? What condition precedent have occurred or been performed? A lot of times in this case, they use these words, we performed everything we were supposed to do, and they say it through condition precedent. And then this guy defaulted by not paying. And I point out in my counter affidavit, there's too many predecessor in interest without identifying who that is. So the whole complaint falls apart because of paragraph 3. Let me just put paragraph 3 up there again for your analysis. Shazam. Sallie Mae Bank was the original creditor or successor in interest to the original creditor. That's sad that they did that, because it's, if you looked at the, we'll look at the loan agreement. Let's look at it now. And Cindy, put up up the loan agreement with Smart Option Student Loan, Shazam. So it says right there, lender is Sallie Mae Bank, Salt Lake City, Utah. So that's enough. They've done their thing, and why do they mess around like that? Even though it's right in the agreement. As a note, Cindy, if you keep that up there, you see the governing law and statute of limitations. Governing law is in Florida. Oh, no, it isn't. It's in Utah. Yes, this is a Florida lawsuit. Why is it not in Utah? If they're claiming you breached the contract, aren't they breaching the contract when they don't follow their own contract, which says you got to be in Utah? So that's another thing that ends up in your counter affidavit, ends up in your answer, an affirmative defenses, and later on the counterclaim. Because they're not going to play ball with me no matter how much I show them how bad they are until you start producing a counterclaim. And now they're going to be paying me. So why are they not happy? Let's find out. Why are they not happy just putting Sallie Mae Bank? Well, they attach a bill of assignment. Cindy put that up. Shazam. And that is Sallie Mae Bank. Okay, as seller, selling something. As the bank seller, each of the SMB trusts listed below, each is a trust seller, collectively as trust sellers. I'm boring the hell out of you, but there's a point. Together with the bank seller, the sellers, Deutsche Bank Trust Company Americas as trustee, the trustee, for the benefit of each trust seller, for value received, blah, 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 blah. What's my point? It's a very good one. Cindy, put up the second page of that, what's called the bill of sale and assignment, which, by the way, has no legal or equitable assignment inside of it. So put up that second page, Shazamski, and there are all the, what they term as trust sellers. First of all, your analysis is where's the assignment or identification of the client's or debtor's assignment between each of these entities, and does this company that claims to have the right to sign for somebody have authority to sign for everybody? But the point being here is now we know why they can't say just creditor, because if they're sellers, how did the sellers obtain ownership? And there must be some modicum of intelligence behind the lawsuit that says, uh-oh, we can't just say Sallie Mae Bank if there's other sellers in the paperwork we're using to support this. It's messy because at our origination, and this thing is cut up into pieces and securitized, there are all pieces of ownership that have to go somewhere. So while they try to clean it up and say all trusts are buying or selling something, they now have to deal with the fact that they've shown that there's more than one original creditor. And they're not original creditors. They could get away with just putting original creditor as Sallie Mae Bank and write that better, that paragraph 3, but they didn't, because they're on a general format of pleadings that is hurting them, and their proof hurts them more. And that's always the case in debt buying lawsuits, because they have to deal with securitization, and securitization, while a good idea at the beginning of a loan, is really bad for debt buyers. So they depend a great deal on your default. Don't let them get away with that. So why is there no creditor? Well, it's too complicated to put who the creditor is. Of course, what do you do with the debt buyer of student loan documents? You use them against them. So all of the above that I've just mentioned to you goes into your counter affidavit, that goes into your answer, that goes into your affirmative defenses, and eventually into your counterclaim. Attached are my affidavit for you and answer and affirmative defenses in Word. But wait a minute, there's more. Here's some fun stuff. After all that, this is typical. I know you don't get excited as I do, but I get excited by this stuff. Sometimes, like I wrote this answer yesterday, and now I just noticed something that I could have included. But I'm going to keep it in my pocket for if some stuff happens, I'll go, well, what about this? So I'm kind of glad that I didn't see this. But after I sat there and my fourth reading of this, what's called a batch assignment, Cindy, put up the batch assignment attached to this lawsuit. Remember, we're using their own documents against them. So, for good and valuable consideration paid, and other valuable consideration, what does that mean? Rock Creek Capital. See, when I was doing this lawsuit, I recognized the way it was written. I'm like, that's a Rock Creek lawsuit. And here they are. But they've gone one step further for some reason and sold this, they claim, to CASA Receivables Management, as it says up there. All right, and they've received CASA claims, all right, title and interest, several years after the that first bill of assignment. This is in 2024, in May. But look at the paragraph, the second paragraph. Cindy, just put up the second paragraph. Shazam. This is the killer. Killer with an A, not ER. Killer with an A. Rock Creek Capital acquired its interest in the accounts in the table of accounts, which aren't attached, by the way, and underlying contracts and agreements related to the accounts in the table of accounts, which again weren't attached, so there's not related, from the original creditor, Ross Education LLC. That sounds, wait a minute, what? Wait, what? Who is Ross Education LLC? Have you heard me talk about them either as the original creditor from paragraph 3? Why is Rock Creek killing this case if it hasn't been dead already for CASA Receivables? They're claiming they got it from Ross Education, the original creditor, which is not true, but there it is attached to the lawsuit against my client. So that's some fun stuff I'm keeping in my pocket. So now you see why there's no solid reference to an original creditor in this case, because there is no original creditor to solidly refer to as the original creditor, because all those pieces were chopped up by the securitization of it all. That's why you have all those educational trusts. A lot of times they're called slabs, SLABBS, I believe. Check that out. Cindy, put up what slabs defined as. I'm probably wrong. But those are student loan asset-backed, and then there's another security, asset-backed securities. This stuff is plunked at originations right into a trust. And you can see the problems that that causes debt buyers who are just hoping that you are one of the 90%. So be one of the 10% and beat this, not only against CASA Receivables, but use it against all student loan buyers. Be one of the incredible amount of members that are on my membership website at collectionstoppersolutions.com. Since Natalie, our great web designer, completely gutted the bad work that I'd done with the site and made it whole and 21st century and real, we're getting amazing, incredible response. And beyond amazing, you're going to love it. And it's for $99. You get over 200 videos, all the templates, all the instructions. You have to look at this face. Maybe I should pay you. But you get a ton of stuff to fight the good fight. I have a lot of clients that they try to go it on their own, and that's a good thing. And they have a number of debts. So there's everything you want. But the point I was making originally with this defense, this is stuff, and I've said this 3 times, that you can apply to any debt buyer case. PRA is a debt buyer. Crown Asset Management, LVNV Funding, UHG are all debt buyers that all use this approach to suing based upon a debt. Again, this is one of the first times I've seen where they can't even get the creditor right. Usually I'm attacking the assignees. And I did some of that in my answers, you'll see. I'll also put on this my show notes and the original lawsuit against my client along with my answer. And that will knock this out of the park for you if you get either CASA Receivables or SLM, a student loan case. It's the same thing, it's just debt buyers. And you can see after something's originated, anybody that buys that, it's a debt buyer case. So there you go. Go do your magic, and we'll conjure up another video for you real soon. Thank you.